taking on the judge overseeing the classified documents case in a new way, confronting Judge Aileen Cannon over her requests for jury instructions that embrace Donald Trump's claims that he had brought authority to take the documents with him when he left the White House. Writing this in part in the filing, the court should be aware at the outset that Trump's entire effort to rely on the Presidential Records Act is not based on any facts. It is a post hoc justification that was concocted more than a year after he left the White House. Also this, saying there is no basis in law.
Welcome back to News Channel, folks. In June 2023, Judge Aileen Cannon was appointed to preside over the criminal case against former President Donald Trump. However, concerns about her impartiality arose when it was revealed that the assignment was seemingly random, sparking calls for her recusal from several legal experts. Stephen Gillers, a professor emeritus at New York University School of Law, suggested that Cannon's previous dealings with Trump in a civil case could compromise her neutrality. Similarly, Richard Painter, Norman Eisen, and Fred Wertheimer, former White House ethics lawyers, criticized her past behavior, which they deemed as fundamentally erroneous. Even Lawrence Tribe from Harvard Law School expressed reservations, fearing that Cannon's involvement might overshadow the trial's fairness. Despite these concerns, Cannon proceeded to issue orders related to evidence examination. The question now looms: will her past affiliations taint the proceedings? Join us as we delve deeper into this historic trial's twists and turns. In a recent court filing, Special Counsel Jack Smith argued that the judge overseeing Donald Trump's criminal case made a major legal mistake. The judge, Aileen Cannon, suggested considering whether Trump could claim immunity under federal records law. Smith believes this idea is flawed, and if the judge rules in Trump's favor, he plans to appeal to a higher court. This could lead to further delays in the trial, possibly extending it beyond the upcoming November election, where Trump is set to run as the Republican nominee for president. Trump is facing a whopping 40 charges related to holding on to classified information after leaving his position at the White House, along with allegations of obstructing efforts to retrieve these records. Despite the charges, he maintains his innocence. Judge Cannon, who was appointed by Trump himself, has been taking her time with the case. Recently, she asked lawyers to think about two scenarios where jurors might be told that Trump could use the Presidential Records Act, PRA, as part of his defense. However, Jack Smith, the special counsel handling the case, strongly disagrees with this approach. In a recent filing, he argued that the judge's legal premise is flawed. Smith believes that the PRA shouldn't determine whether a former president is allowed to possess highly classified documents under the Espionage Act. He insists that focusing on the PRA and jury instructions would distort the trial's fairness. Essentially, Smith is saying that the PRA shouldn't even be considered in this trial.
100% right. There is absolutely no connection to the Presidential Records Act to this case whatsoever. It does not allow former President Trump to have said that certain documents are personal. Even the 11th Circuit, in considering the special master claim, made it very clear that Donald Trump has no possessory interest in these documents and that they do not belong to him. This is just completely off the wall.
Completely off the wall as an argument, but if you read the subtext, I think the subtext...
While on the other hand, a recent development in this case happened when judge rejects Trump request to dismiss classified documents prosecution.
Trump had argued that the Presidential Records Act allowed him to transform those as personal property and retain their position at his Mar-a-Lago club in Florida. However, the judge struck down the one primary defense put up by Trump, suggesting that the case was indeed heading towards trial. Prosecutors had argued that Trump was not authorized to keep secret information related to U.S. national security, even if he viewed the records as being personal. But that's not the only...
Lawyers for Trump had cited a 1978 statute known as the Presidential Records Act in demanding that the case, one of 4 against the presumptive Republican nominee, be tossed out before trial. That law requires precedents, upon leaving office, to turn over presidential records to the federal government but permits them to retain purely personal papers. Trump's lawyers have said he designated the records as personal, making them his own property, and that decision cannot be second-guessed in court. prosecutors on special counsel. Jack Smith's team countered that the law had no relevance to a case concerning the mishandling of classified documents, and said the files Trump is alleged to have hoarded at his Mar-a-Lago estate in Palm Beach, Florida, were unquestionably presidential records, not personal ones, and therefore had to be returned to the government when Trump left the White House. U.S. District Judge Aileen Cannon, who heard arguments on the dispute last month, permitted the case to proceed in a 3-page order that rejected the Trump team claims. She wrote that the indictment makes no reference to the Presidential Records Act, nor does it rely on that statute for purposes of stating an offense. The act, she said, does not provide a pre-trial basis to dismiss the case. The court's order soliciting preliminary draft instructions on certain counts should not be misconstrued as declaring a final definition on any essential element or asserted defense in this case, Cannon wrote. Nor should it be interpreted as anything other than what it was, a genuine attempt, in the context of the upcoming trial, to better understand the parties' competing positions and the questions to be submitted to the jury in this complex case of first impression. Charles Coleman pointed out that while Judge Cannon is being criticized for potential delays in Trump's classified documents case, it's actually Trump's own lawyers who are responsible for dragging things out. They've been using tactics to delay the trial, hoping to push it past the election or even avoid it altogether.
We were on together. You were talking about Judge Aileen Cannon. You had said that, quote, evidence of her bias is pretty palpable. You said she was grossly incompetent. Then today you got to read the ruling. How do you feel after you saw it?
So I think she had an opportunity today to listen, to review the criticism she received yesterday, not just from me, but from many other commentators. And I think it triggered a fight or flight moment for her. And instead of fighting or flying, she flailed. Keep in mind that this ruling is on a motion that has probably a cumulative total of 50 plus pages of legal briefs, detailed citations to the case law, Jack Smith making it plain that the Presidential Records Act has nothing to do with the case, and that not only should Trump lose the motion to dismiss, the Presidential Records Act considerations should be completely withdrawn.
In the New York case, the trial is set to begin on April 15th. If Trump were to be re-elected president, he might be able to get the federal charges dismissed or pardon himself. However, he wouldn't have the same power over the state charges. Smith's filing also mentioned that if Judge Cannon allows Trump to use the Presidential Records Act, PRA, in his defense, Smith would have the authority to appeal to a higher court and seek a writ of mandamus. This could further complicate the legal proceedings and potentially impact the trial's outcome. While it's crucial to analyze various aspects of a case, it's equally important to maintain faith in our judicial system. Delving into the integrity and intentions of judges involved in political cases may undermine this trust. Our legal system is designed to uphold justice and fairness, and we should trust that judges make decisions based on the law and evidence presented before them. Make sure to hit that subscribe button and ring the notification bell to stay updated on the latest developments. And as always, feel free to share your thoughts in the comments below. Until next time, stay curious and stay informed.